You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury, and happy Freedom Friday. As always, I'm extremely grateful for each and everybody who's tuning in and giving us a listen. We wouldn't be able to grow our community and our message and our passion without you, and so I greatly support each time you click download. Today is a first for me on Members of the Jury. We're actually going to break down a type of motion that resulted in another beautiful word that us public defenders and criminal defense attorneys love to hear, and that's a dismissal. And one of the reasons why I'm so excited about this episode is because so much of what people think criminal defense is taking matters to trial. But before cases can ever get to trial, they have to be scrutinized through the motion process. And a lot of times on this show, people will hear me say that the way that I view my job is a protector of rights and of the Constitution, that I am the safeguard to make sure that everybody in the criminal justice system is doing their job properly. And one of the first things that we do in any criminal case is scrutinize the police activity to ensure that what they did was lawful. And I think in my experience, this is where a big philosophical difference occurs with people and their view of the criminal justice system. To me, and I believe my colleagues and my realm of the universe, if an officer acted unjustly, stop the bus point blank, that no criminality or criminal conduct matters. There are others who think, well, if there was only a small violation of the rights, and at the end of the day, we got a potential criminal off the streets, the better. And I think that that's where, you're not going to change philosophies, but thank God that we have individuals like me, like my guest today, and other public defenders to scrutinize those police to make sure that their conduct was lawful. And so joining me today to help me break down this motion is Deputy Public Defender Claire. Claire, please introduce yourself to the members of the jury.
Hi, everyone. My name is Claire. I work in a rural Texas office where we deal with a lot of sort of things that Lucas was talking about, a lot of police misconduct, and maybe not the best candidates for police officers, and the departments just kind of have to do their best with what they have. And maybe they're not fully educated on the law, and that's where we come in to educate them.
Oh, and I love that you started with that out the gate, because that's really a big crux of cases, because, and honestly, somewhat of an issue with policing and its institution is that they try to, police officers are law enforcers, but at the essence of it, they don't have an understanding of the laws in which they are enforcing. I mean, you have police academies that range from 6 months to maybe a year and a half, whereas the minimum law school program is going to be at a minimum 2 years, and that's making sure you're doing the above average amount of credits, because a general time is going to a default time is going to take you 3 years to graduate. And so just because you're told this is what the law is and this is how you enforce it, we see it time and time again and that doesn't necessarily mean that a cop is doing it intentionally or maliciously, although I think that there are examples where you could find that, but it's really a lot of times just an ignorance of the actual meaning and essence of the law. And so I'm really excited to break this down. So why don't you first off start with us? What is your practice before you actually decide whether or not to file a motion?
Once a case is indicted, I'm sent all of the discovery. So offense reports, witness statements, body cam, and the most important, I think, is body cam. So I'll go through the offense report and I take notes on it. I take a pretty detailed log note of it so that I know what I'm looking out for on the body cam to see if it all matches up. And so on this case in particular, I already had some red flags going up with the offense report. And I was like, I got to see the body cam and see how this really played out. A lot of the time, I don't want to say a lot of the time, but sometimes police officers, I feel like don't know if this is intentional or if this is just the way they remember it, but their offense reports aren't exactly in the exact same order or aren't an exact match to the way that it went on the body cam. So I always tell people, like, if I'm doing a training or something like that, you gotta watch the body cam, because that will show you the truth of what really happened.
Oh, I couldn't agree more. And I think the introduction of body cameras into our practice or in criminal law in general has had such huge benefits. I remember when I was an intern, one of the first things one of my mentoring attorneys told me was that, when you're reading a police report, you really have to remind yourself that this is not an objective statement of facts. Like, there is an underlying goal and mission of this report, right? And that is to lead to an arrest and or charges. And so knowing that it's written with that, from that perspective, really opens up the possibilities of like, okay, well, if you approach it the same set of facts from different perspective, what then would the truth rely? And so I think that when you have now body worn cameras, you see that in 4K, especially in 2023, that contradiction of perspectives, because there's plenty of times where an officer's own body worn camera will impeach the way in which they wrote the report. So I think that that's so huge. And so take us into this motion and in this case. First, I would ask you, give us a general breakdown of the facts or as they were alleged, and then whether or not in this case, the body worn camera played a key role in being contradictory to the police report.
Yeah, so it's a possession of a controlled substance case. I get so many of these. Probably half my caseload is possession of a controlled substance. It was 1 to 4 grams. So in Texas, that's a 3rd-degree felony, which is 2 to 10 years in prison. And he was looking at prison time was the offer. So I'm going through the report, and it says he has a warrant for his arrest, which is on an old DWI case out of the county. And because I guess he has a history of either running or fighting, they got about 4 officers to serve this arrest warrant. And so the report says they come up on him while he's working on a car outside of his house. They immediately detain him in handcuffs. They asked him some questions about what was in the car that he was working on. And the report says, so he's in handcuffs, he's put in the back of the car. The report says that they saw in a backpack in, quote, plain view, some baggies. And, anytime you see baggies, the immediate thought is they think that it's going to be a controlled substance in these baggies. But the way the report was written was, okay, they see these baggies in plain view, and then they found this little red bag. And this little red bag they thought was very important. It turned out not to be important at all. They saw a little red bag on the ground that had some residue in it. And then the way the report is written again, then they look into that backpack and the baggies, and they find like a rock of meth, essentially. It tested to be a little over a gram.
I want to interject right there because this is already so fascinating to me right out of the gate, because the fact that I know essentially kind of the pathway that you're going is crucial, because you, from my understanding, have said that they're basically acting on a warrant at this time, right?
Mm-hmm. They're acting on an arrest warrant.
Which is crazy, because in my experience, the majority of illegal searches are because there was a warrantless stop and detention. And, that is inherent in our Fourth Amendment, ladies and gentlemen. So just know if you're ever stopped without a warrant, they can demand one. They can't search you. And there's extensions, but definitely at your house, always ask for a warrant. And so I'll let you continue, because that's amazing that we're about to go down this route even despite a warrant, because generally when those are issued, they're like Willy Wonka golden tickets for officers to go through any and everything. So yeah, so please continue.
Right. So then we watch the body cam, right? And it's all the same. It starts out all the same. They do kind of like 4 officers kind of rush him. And actually, a note on the body cam. The officer that wrote this report, the officer that was the subject of the motion, didn't have his body cam. It said, like, his report said something about body cam couldn't be activated for this, something like that. But thankfully, another officer who actually kind of hung back during the whole interaction, he had his body cam on. So he actually gave us kind of a whole, like a wide view of it, which I enjoyed. Anyway, so I'm watching his body cam. And it shows them kind of rushing up on my client. They immediately detain him. They ask him some questions about what's in the back of the car. And already I'm like, this is a Miranda violation. Like, but forget the evidence, like you can't ask him questions when he's under arrest that could be incriminating.
Let me ask you right there, because not all my listeners may know, what was about that specific set of circumstances that triggered a Miranda violation? And I guess maybe give them a general definition of what a Miranda violation would be.
Yeah. So, as everybody sees on like cop shows, it's once you're arrested, they're supposed to say you have the right to remain silent. Anything you say will be used against you. You have the right to an attorney, all of that good stuff. Well, Miranda v. Arizona says you have to read those rights, or a police officer has to read somebody those rights if they are in custody and they're being interrogated. So if it's just you're just passing on the street, they don't have to read you those rights. And there's a lot of case law about what actually is being in custody. But for our case, right, he was under arrest. Like, he's in handcuffs, he's under arrest, he's in custody. And interrogation is just questioning. So if somebody randomly says something, if they randomly say like, yeah, I killed him, like, without being questioned, then they didn't have to read the rights. But once they're being questioned, those rights have to be read. They have to be advised of those rights. So because he wasn't, that was actually part of my motion. It was a very, kind of forgotten about part of the motion. Like, even the prosecutor was kind of like, shouldn't this be a separate motion? I was like, it was in my motion. Anyways, so because of that, yes, I also said that his answers to those questions should also be suppressed. And I'm going to be honest, I couldn't even really hear his answers to those questions on the videos. They didn't really incriminate him that much anyways, but it was still like, kind of as a matter of policy, like, that's got to be suppressed.
Yeah, and I couldn't agree more with you. And I have to give the disclaimer to just, God forbid anybody who listens to this podcast ever has a case, just because you're not read your Miranda rights. If you do not say anything that was incriminating, your case will not get dismissed. Okay.
Right.
So we're going to go down this ride. I think every public defender has had that. They didn't read my Miranda rights, so my case needed to be dismissed. And it's like, well, did you say anything incriminating? No. So like, well, then there is no issue necessarily with that violation. So
even if you did, those statements would just be kept out. It wouldn't be dismissed. I'm sorry. Yeah, that's
unless the case was just those statements, which it's never
right,
is. So.
Which it rarely is. Yes, exactly.
I'm glad that you had that experience with me as well. Okay, so in this case, you're going through the discovery and you're noticing that, okay, they have him in custody, because I would agree with you more. I mean, when you already just going through the facts, one of the things that I noted was the immediacy of handcuffs, because, and I get it, in your particular situation, the warrant may have warranted that, but especially in situations when there is no warrant, the instant a handcuff is on, that does definitely take away any officer's ability to try to say that this is now a still mutual contact or anything. So that's definitely a red flag for me when I look out for my motions as well. So after your client started, okay, so he says something, but you're not sure to what effect. What was the next part of discovery that you were going through?
Yeah, so he answers some questions. They're just like, okay, whatever. They put him in the back of their car. And that's kind of another moment in time where you're like, okay, there are certain things that should or shouldn't happen at this point. So he's put in the back of the car, and immediately they go over to the car that he was working on. They pull that backpack that they had talked about in the report, pull the backpack out and start rifling through it. And you can see in the discovery, this is what actually I thought was hilarious. So, they see baggies and they think baggies automatically means there's going to be some kind of drugs in there. Those baggies that were sticking out of the backpack, those were empty. There was nothing in them. But they keep picking through the backpack, and then they find a baggie with something actually in it. And so later after that, that's when they found that little red bag that was on the ground with residue. And so that's the discrepancy between the report and the body cam, because it kind of seemed like they might have tried to use that red bag as like probable cause to get into the car, even though red bag is outside the car. Still a stretch, right? But that red bag was found way after they started picking through the backpack, and that that was a key point for sure.
Well, and let me pick your brain there for a moment then, because are you contesting that that wasn't your client's bag, or even if it was, they wouldn't have a right to search it?
Right. So they're calling it a search incident to arrest. And
right. And that's where I was thinking they would justify it as.
Right. Yeah, so the argument isn't that it's not his bag. If we were to go to trial, that might have been the argument. But on this motion, it's whoever's bag it was. If it's evidence being used against him, they didn't have the right to be going into that bag.
Okay, so you file your motion, and then, which is basically, well, in this case, yeah, what was your basis? Because generally speaking, again, we would say, this whole thing started because of there was no warrant. So what was your first initial argument because when we're filing motions to suppress, we carry the burden to essentially prove that they didn't have that. And so what was in your initial paperwork?
I kind of just have a boilerplate motion where I fill in what the agency was who violated the rights, and then I say what step was where the rights were violated. So if it's the stop, right, they don't have reasonable suspicion for the stop, or the search, or questioning, or arrest. And so I put in the questioning because of what we talked about with Miranda earlier, and then the search of his belongings or his property or something like that. So just kind of a boilerplate motion. And this is just like how we do it in our court. I don't typically have to put whether there was a warrant or not in the motion. It'll be when we go to court on that hearing, judge asks, was there a search warrant? And in this case, I say there was an arrest warrant. There was not a search warrant. And then the burden falls to the state to prove that the search was reasonable.
And so then after you filed your paperwork, the prosecution filed a response kind of justifying the police's actions?
No response. They just
interesting.
Yeah, and again, it's probably just a local practice thing. There was no filed response. It was just like a phone call before, doing a docket rundown. They're just like, so why do you think you're going to win on this? And I'm like, because it's not a valid search incident to arrest. And I even gave them the case, and they go, I remember the response was, I don't think that's what the case law says. And I was just like, okay, whatever. Like. And we get to court and we argue it.
And if I had to bet, the prosecutor that you were talking to didn't actually read the case that they thought that they were going to use in their argument. I feel like they always get it from someone secondhand, and so they don't have like a true understanding of what the case is really about. They know a holding and then try to just argue it, but without knowing the nuances of the facts.
Yeah, or even, I mean, the holding of this case, it's Arizona v. Gant, by the way. It's a 2009, I believe, Supreme Court case. It's a simple case, and even the holding, like, is pretty clear to be in favor of me. I think it's really just, I don't want to use the word gaslighting lightly, but I feel like my prosecutors do kind of gaslight me sometimes to kind of intimidate me out of arguing emotion. They're like, no, you don't know what you're talking about. Like, and
no, I think they're trained on that. I think like, like not only do they want to dehumanize, not only do they want to dehumanize our clients, they want to try to like make us seem like inferior lawyers too when possible. So
yeah, and I mean sometimes it works because like I should have mentioned this. I'm 4 years in, or almost 4 years in. They both have over 10 years legal experience now. As far as being prosecutors, the elected county attorney, same time as me. Like we literally came in at the same time. The assistant, I want to say she was a prosecutor in another area and then came over and started at ours. And so they have a lot more experience than me. And so there are times that I learn from them and I'm like, yeah, you're right. Like you are right. But on that one, I was like, no, I'm pretty sure I know what I'm doing here. So
yeah, that's so interesting to me to hear that they didn't have to file any kind of paperwork for the justification. Because yeah, just jurisdictionally speaking, that's how we would file a motion and basically give a basis as to why we think it was unlawful. And again, most of the time that justification is that this was a warrantless search. And then they have the burden basically to respond in paper as to the different justifications that an officer may have. I was surprised, they didn't just file something to say plain view, because that's why officers love to put that in their police reports.
Love plain view.
Yeah, I love plain view. Okay, so despite them not filing any response, does then in your jurisdiction, do you guys have like an evidentiary hearing on the papers where they call the officer as like a witness?
Sort of. So yeah, so once I filed a motion to suppress, they just set it for a hearing. Like we don't really go back and forth in paper. Maybe it's because our judges don't want to read all these paper filings. I don't know. Like, they'd rather hear from the witnesses. They'd rather see the body cam themselves. And so we just set it for a hearing. And that's where I say, Judge, this was a warrantless search. I gave them a little brief intro. I say, like, they're trying to justify it as a search incident to arrest. The case law doesn't support, that this was a valid search incident to arrest. And then the state goes. And yeah, they only put on that one officer that actually, and I'm not even sure why they put on just this one officer. I feel like the other officers could have helped him out a little bit, but they just put on this one officer, the one who did actually go through the bag and arrest him for the possession.
Well, and so break that down for me, how the prosecutor did that, because, obviously at this point in time, there's no hiding the ball as to what conduct you're saying is unlawful, and the prosecution has a heads up about that before this examination even starts. And so, that they're going to try to curb the examination to basically knock out your points. So what were they trying to do that?
Two things, I guess. So they're kind of trying to say, frankly, I think they just didn't really know the search incident to arrest law. And so they're saying, okay, why were you there? It was an arrest warrant. When was he detained? When was he put in the back of the car? When did you search? And then they get into that little red baggie. Because again, I think, and their closing was not clear at all. Like, I think they're trying to say plain view, also improbable cause, also in search incident,
It got to be one or the other. Like, it can't be all three.
Yeah, they're like, yeah, exactly. They're like, if it's not this, then it's that. They're just kind of throwing stuff at the wall and seeing what sticks.
I love when they do what we're supposed to do.
Yeah, I'm pretty good at that too, But yeah, they ask, like, what did you find in the bag? Like, they're, just basic direct examination, like nothing too crazy. And on cross, I only had maybe 6 questions, so I say,
oh, wow.
Yeah, it was very, very quick. So I say, what was he being arrested for? He was being arrested on a warrant. What was the offense of that warrant? And they say a DWI. And I'm like, do you know when that DWI was? No, And so I basically got the officer to say he would not find evidence of that DWI in the car when he's searching. And that's kind of the whole rule of Arizona v. Gant is if you're searching incident to arrest, it needs to be for the offense of that arrest. You can't, if you're not going to find evidence of an old DWI, then there could be an officer safety justification. That's a little different, but you're not going to find evidence of that. And so you don't get to just poke around. And so the officer admitted, yeah, he was like, I'm not going to find evidence of that DWI.
Wow, I'm glad you broke that down, because I didn't even realize that. You get so accustomed to just, especially search incident to arrest cases, it's just like, well, once someone's designated under arrest, cops certainly don't treat them as if they have any Fourth Amendment protection like that. So I'll have you share that, if you don't mind, sometime when you get a chance. Email me that case. I'll put it in this episode show notes so that I can read it, and anyone who wants to also check it out and potentially cite it will have the authority to do so. So that was awesome. Okay, so that's great. So then you get the admissions from the cop, basically to establish your points, where now you think you're within the confines of this case law. How is that the extent of the motion hearing, essentially?
Pretty much the rest of my cross was just, where was my client at that time? And, he says he's handcuffed in the back of a police car. And that's getting to the officer safety justification, because, and like, I want to tell you, like, search incident to arrest, I agree. Like, I think us and officers were kind of just like, once they're arrested, like, they're screwed. Like, you can search, but it is really, really important to keep in mind, like, it depends on the offense. It depends on where they are. And yeah, that's very easy to overlook for us and for officers. And so again, it gets back to, I don't think it was really intentional. I think it was just, they're kind of on autopilot. But anyway, so he says that he was in the back of the car. So there's no chance that he can reach for weapons or anything like that. And then I provided the case law to the judge, and I said, Judge, this is the case law. It's pretty clear that neither of these justifications exist. And Judge, I was really hoping he'd rule on it right then. But he said he wanted to take it under advisement. Yeah. And that's the worst, right? Because you got to wait. And you don't want to like bother, I didn't want to bother him and be like, hey, like, remember that motion? I think a whole week, maybe a week and a half passed until I got the order on that. But I did get the order in the email, and it says it was granted, and I was just thrilled. But yeah, that was pretty much it.
And so since you were able to get that motion granted, what effect did that motion have on that specific case?
So granting the motion says that they're going to suppress, or the judge is suppressing that evidence, which is the rock of meth that they found in the backpack, right? And that can't come in at trial. And so if that can't come in at trial, the state can't prove their case. And so, and there are situations where maybe, like we were talking about with Miranda, they can still probably use other things. But when that's all the evidence they've got, when that's what the person's charged with, not much else they can do there. And so I had to wait like 3 days for them to dismiss the case. I know, I was like, come on, like, I know you just want to keep the guy in jail as long as you can, but I sent over to their assistant because, like, again, it's a really small county, like it's just me and them. And so I sent over to their assistant who's very nice. And I was like, I sent a GIF of like a cat, like going like this, like just
that's hilarious.
Like just like waiting for my dismissal. And then I got it like 30 minutes later. I was like,
that's fantastic. and I love that because one, I don't doubt you, like they're probably going through that police report again to see if there was any last minute charges they could potentially get out of that. But, that's such a beautiful example of, why we are embedded in the Constitution, why, our existence in the criminal justice system is so imperative. And I think that goes back to, essentially the introduction into the show. It was like, here you have someone who, at the end of the day, was in possession of a controlled substance, I guess, allegedly, unless, I didn't hear anything about them testing it, but nonetheless, even if that's true, but the way in which the officers were able to discover it violated that man's constitutional rights. And one of the things that irks me in this country is somehow, some way, there are individuals who somehow try to put a hierarchy to constitutional rights, because there is a whole subset of this country that, wants absolutely zero exceptions to the Second Amendment, to the First Amendment. But even if you look at the case laws and the way that statutes are written as they apply to the Fourth Amendment has been dissected, disintegrated, and there are so many different exceptions and allowances for people to get searched and seized by law enforcement. So the fact that you were able to go through what sounds like a lopsided set of facts, going through, overcoming a legitimate lawful issued warrant, something that was within close proximity to your client, something that was quote unquote in plain view. The fact that you still had the wherewithal to know that there was something wrong with that, to be able to find that case law and then even persuade a judge, where I don't know about in your jurisdiction, but in my jurisdiction, you got a good 75% chance that judge was a former prosecutor himself. So to persuade that type of authority is very, very impressive, Claire. So congratulations. Well deserved.
Thank you. It felt amazing. And this client, he is just one of the sweetest guys I've worked with. And like, he was so patient this whole time. Like I said, he was waiting in jail this whole time. And I got to bring him the dismissal. Like, I printed it out and I went over to the jail and I sat it on the table, like upside down. And I could tell he walked in and he was like, oh crap. Like he thought it was going to be bad news. I flipped it over and showed it to him, and he, it takes him a minute to kind of process it. And he was like, no way. Like, he was fantastic. Just thrilled. That's just like the best moment. That's the best part of my job, is getting to give them that.
Absolutely. And, to the members of the jury, Claire, as well as a lot of my recent guests, were able to connect online, which I highly encourage everyone to follow us on social media at MOTJ podcast or at members of the jury. It's been a couple of weeks since we've been able to actually connect, because we both live in the, the full-time life of active attorneys. And so we were finally able to link up today before the show, and she had a little bit of interesting information as it related to the officer in this motion, and which was funny, because I was expressing to her that I think it's pretty common that, especially within close-knit defense communities, specifically public defender offices, is that any time one of us win one of these rare motions to suppress, we alert all of our colleagues as to who the officer was, what agency they were working with, just because, if they violated individuals' rights once, more likely than not, they're going to do it again, even if it's intentional or not. And so, and just like they like to think of our clients as repeat offenders, Claire, go ahead and let us know the information that you found out.
Yeah, so this officer, so I had another client, another case, and this one was actually interesting because he was over in court on a bench warrant from TDCJ. He was going to parole out pretty quickly, but he just had this one case to resolve, and they were offering essentially time served. He would have had to do another 1 or 2 months, and they wanted to get it done quickly because he was on a bench warrant from like West Texas, so it was like a 9-hour drive. They didn't want to take him back. Anyways, so it's like the end of the court day, and I just got appointed to him in court. And so we go back into the back room with the prosecutor's file, and I'm like, let me just look through everything, like if it looks okay, then sure, you can take this plea, and we go through it and same officer, but at that time I hadn't won that suppression yet, right? So I didn't really know if I'm, scrutinizing this officer extra. I'm just reading it.
Got it.
And the officer says, so the report says shows up at like a motel parking lot for a disturbance between a man and a woman. The man is my client. And when he shows up, they both say, it's nothing physical. Like, he just needs to take his stuff and go. And so the officer, let me think. I think he asked for my client's ID. And so he goes into his wallet, he gives him an ID. And the officer sees a little knife, like a little tiny blade in there. And he's like, hey, I saw that blade. Can I just hold on to your wallet for a second, while we do this? And that's fine, right? Like, officer safety is the most important thing, right? So yeah, he gets to do that. And then it said something like, upon closer examination of the wallet. And I'm like, what do you mean closer examination? And it said, again, there was a baggie in plain view. And so he pulls the baggie out, and it has meth in it. And it's, again, less than a gram, possession of a controlled substance. That one is a state jail felony in Texas. So it's 6 months to 2 years. And I read that and I was just like, oh, you're not taking this plea today. I was like, I'm sorry. Okay, no, because I like my clients to make their decisions, right? I was like, fine.
No, but a strong advisal against it, especially when, it's one thing when the facts are, and you know what I mean, but when you got a constitution violation, and one of the things I always try to emphasize, because I totally get that too, is because, it's not uncommon too that when you essentially try to fight a case that down the line the initial offer is going to get worse, and then your client is in a worse situation. But I really like to press hard against that. We all know that there is the existence of a trial tax. Like if you take your case to trial and get convicted, you're going to look at more time than you did originally. But I really push against that in the pre-trial stage, that just because someone is arguing that their constitutional rights were violated, they shouldn't be punished. If they want to try to play hardball with the prosecution and just, try to, hardball their way to a better deal, okay, I could get how the prosecution responds that way. But when we tell them as counsel, look, we think that at our advice, they should fight this case. Like, I hate to see in any situation that gets worse for a client for doing that. So I totally understood what you meant by that situation and the strong advisal.
Right. And 100%, that's what happens in my county is, they'll say, okay, before the motion, this is the offer. If we have the hearing, this is what the offer goes up to all the time. And again, like, I think that's crap. I think it should be an ethical violation. It's not. This, they say that you can do that. I was blessed to work in a county one time with a county attorney who I asked him, are you going to make, what's the offer going to be after we argue this? And he was like, what do you mean? He was like, I'm not changing it. I was like,
I always like to respond, if I win this motion, all my counter offers are off the table.
That's funny. But yeah, I mean, that's the situation. They're like, okay, the offer's 9 months now. It's going to go up to 12 if you argue this. And so I have to tell my client that, like, if we lose, it could get worse. But I was like, but please, like, give me the opportunity. Because again, we're in court. I'm like, let me watch the body cam. At least give me this reset. Let me watch the body cam. And for context, resets in my county are a month, right? Because our judges only come once a month. So I was like, please just give me this reset. Let me look at the body cam. If I think it's worth filing, I'll talk to you, but I'll tell you honestly if I think we should file it or not. And he's like, okay, like this is my first time meeting him, and I don't know why, but he completely trusted me. He's like, I'll give you this reset. So we get the reset. I look at the body cam.
Are you dealing with the same judge? And I know you're dealing with the same officer. Are you dealing with the same judge and prosecutor?
Same prosecutor, actually a different judge. And this judge on this one, I did not think would grant it, but she was actually out that day. She actually had a visiting judge who was from Houston. And I kind of already knew that was going to work in my favor because Houston is, it's largely like Houston is a blue county, right? And so I'm like, I think that that's going to work out for us. And turns out it did. But I'm honestly not sure if our original judge would have granted that.
So walk us through this second hearing with the same officer. Did it kind of go very similar to the first? I mean, were you obviously your arguments were different. Just give us a little breakdown of that hearing.
Yeah. So the offense report and body cam pretty much match in this situation. Like he says, can I see that wallet? Holding on for a second. And as he's talking to my client, his body cam was kind of blocked by his arm, but you could see him kind of rifling through the wallet. And then I heard my client say, I don't know what the hell that is. And that's when I'm like, okay, he found it, right? So we have the hearing, and instead of saying, it's a Terry frisk or he had the right to do that, they claim again, plain view. That's like their favorite thing.
God.
And then I know. And there's a Texas Court of Criminal Appeals case that says plain view of a baggie alone, just the baggie. If you don't see the substance, that doesn't count as plain view. It's not immediately recognizable as contraband or whatever. Maybe if there were more facts, if client says like, yeah, I got some meth in my wallet, I mean, that's done. But anyways, so we go into this hearing and I'm thinking like, how are they going to twist this? Right. And they didn't just say it's plain view. The officer said that he saw specks of the substance, specks of meth above the Ziploc baggie line, right? And, and so, I mean, that's immediately like BS monitor going off. And that's what I'm crossing him on. I'm like, so you saw it above the line where it wasn't locked? Like, okay. And I was like, you see these teeny tiny little specks, like, and they're just little, like less than grains of sand, and they don't have any pictures to show like this is what he saw at the time or anything. And you can't see that on the body cam. And this visiting judge, he was like, I want to watch the body cam. I'm like, okay. And so he got a laptop and he watched it there in the middle of court. And, he was very funny. He wasn't very, formal with his procedure, like he's kind of just talking it out with us, like instead of my argument, their argument, my rebuttal or whatever, we're just sort of having a conversation. And I was like, I don't believe that he actually saw that wasn't in his report. I read out the sentences of his report that said, upon closer examination or whatever, I saw this baggie, and it doesn't say anything about the specs of the substance. And yeah, judge, he just said, yeah, I don't believe that this was plain view. I'm going to grant it.
Oh, wow. Okay. And so I'm assuming then, based on what we learned from your last case, that ultimately if the items suppressed are the basis for the charges, that I'm assuming just like the last case, this one ended in a dismissal?
Yeah. And so
yes, sir.
They didn't make me wait a few days for that one. That one was right there in court. But then client also had a failure to appear. This failure to appear was while he was incarcerated. So that's also like an automatic dismissal. They know that. And that was like in writing that they were going to dismiss it. But I hadn't gotten that dismissal yet, or I didn't know I had. I got it last time in court. It wasn't uploaded or whatever. So I was like, so what about the failure to appear? And the county attorney goes, oh, he's still getting that. And I was like, no, he was in custody, like he's just immediately like thrilled that there's another thing that they can incarcerate, Once I was like, no, he was in prison. And his assistant was like, we did that last time. I was like, oh, my bad. I didn't have the copy. So yeah, he's free of all charges.
And obviously it wasn't that obvious if the other person was still trying to be like, yeah, he's going to get that conviction.
Right.
So,
right.
yeah.
And so, so he walked out. I mean, he had bond. I guess he paroled out and then he bonded out on our charges. So he was actually not in custody at the time of that hearing, but he was scared that he was going to have to, agree to go to state jail or do probation or something like that. And he walked out. I actually saw him at Subway later. That's where I go for lunch. Not sponsored, right? But I saw him at Subway later and he was like, hey, can I get your card? He was like, he was like, that was awesome. I was like, yeah, thanks. I thought it was too. Anyways, it was cool. I love 2 happy clients. We very rarely get good outcomes in this job. And so when you do, you really gotta celebrate it, I think.
I couldn't agree more. And, that's what the essence of this show is, some way, somewhere I'm trying to connect with public defenders to, highlight their victories because, we're quick to see news and articles and all types of awards going out to prosecutors and those, fighting the good fight. But, there's a podcast called Another Not Guilty that says, this is the side that nobody wants us to hear. And except for those who are in it, and I think that's not true. We're warriors just like the other side, fighting for the same, people that they are. It's where I come from. We say, we always make fun of the people because the prosecution because they say on behalf of the people, and we always rebut with them that we represent the people too, just one at a time. And so, I really appreciate you giving us your time, you giving us an insight into your knowledge. You definitely taught me something, which I'm always grateful for. That's the goal of the show, is for me to learn something new, for the audience to learn something new. And yeah, to hear 2 victories on Freedom Friday, that's an extra kind of special bonus episode. So I really appreciate you giving us the time and that knowledge. We always ask our guests the final question on this show, and that's, what is the significance of taking matters to the box?
I think whether you win or lose, like I said, a lot of times we don't get these good outcomes. I think it means so much to a client just to see us fight for them. I have a lot of clients who say nobody has ever fought for me like that before. And even when we lose, even when they're, they have to go serve a lot of time in prison or something like that, they're still grateful because somebody fought for them. Sorry, I'm getting emotional because I'm thinking of all those clients that just love, that's what means the world to them, because everyone else in this system is against them. Like the prosecutors, the police, even the judge, is very harsh on them. And just having somebody who cares enough to put in the time and the effort to really fight for them, whether we win or lose, even if we know we're going to lose, it still means a lot to them. And so it means a lot to me.
That was really beautiful. And I couldn't agree more. I mean, I say first we fight for justice. Second, we fight for that thank you. Because that really resonated with me when you said win or lose, when a client is happy that we fought for them, that we told their side of the story for them. And especially in such a overbearing, powerful system where it is so many people against you. I'm really thankful for that message that you just shared and for your appearance on the show today. And like your clients, I'm grateful for that they had you to represent them and give them some Freedom Friday. So thank you so much, Claire. We really appreciate it. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion.
with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.